Good afternoon. My name is Daniel Martinez de la Vega. I'm an employment lawyer in San Francisco, California. And briefly, I'm going to talk about jury instructions 2522A, hostile work environment, conduct directed at the plaintiff, the employee, the essential facts and elements against an individual defendant under the Government Code section 12940J. And what a jury instruction is, it's actually what the jury would hear before they deliberate. So after they heard your case, after your case is closed, before the jury makes their decision, the judge would actually read this to them. And I'm just going to read it briefly. That the plaintiff, the employee, was an employee of the person providing a service under a contract or non-contract. That the plaintiff was subjected to unwanted harassing conduct because he or she was believed to be or was associated with a person who was associated with a person who was believed to be in a protected status, that the harassing conduct was severe and pervasive, that a reasonable person in those circumstances would have considered the environment to be hostile or abusive, and that the employee or the plaintiff considered the work environment to be hostile and abusive, that the defendant participated or assisted in encouraging the harassing conduct, and that the plaintiff was harmed, and that the conduct of the defendant was a substantial factor in causing the harm. So a lot of times people or clients ask, what's severe? What's pervasive? What would make a workplace hostile, and what is considered severe and pervasive? And there's actually another jury instruction. It's important that not only your lawyer, but that this is considered when considering filing a claim for a hostile work environment. It's jury instruction 2524. It actually defines what's severe and pervasive. So, for example, if you're in a work environment where you believe your boss is harassing you because you're African American, what would be considered a hostile work environment? How many comments, how many derogatory comments about your race, or how many statements, or what kind of actions would be considered enough to be considered hostile, to have this complaint? So I'm just going to briefly read what severe and pervasive is. Under 2542, severe or pervasive means conduct that alters the condition of the employment and creates a hostile or abusive work environment. In determining whether the conduct was severe or pervasive, you should consider all circumstances. You may consider any or all of the following. So the jury would consider A, the nature of the conduct, B, how often and over what period of time the conduct occurred, C, the circumstances under which the conduct occurred, D, whether the conduct was physically threatening or humiliating, and E, the extent of which the conduct unreasonably interfered with the employee's work performance. So this is a very fact-intensive claim, and it's important that the attorney who's reviewing your case or reviewing a case understand the law, understand and really hears and does a very thorough client intake or factual investigation of every instance of harassing conduct, every instance of what went wrong in the workplace in order to fully prosecute your claim and be successful.